How far can a state go to regulate the right to bear arms? Can a state override a person's property rights? Can Hawaii proactively prohibit lawful gun owners from carrying on private property without the owner's prior consent? That's the question in the Supreme Court case Wolford v. Lopez. We'll take a look at that case next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach, Rise, and Generation Be Free. Glad you could join me for today's case. It's an interesting one. It's rare that a case where a state actually tries to infringe on both your right to bear arms and your right to own property at the same time. I'll get into that in the thing. To find out more, if you want to follow up with this case and check my sources, well, head to constitutionstudy.com. Look up this article. All my quotes have links to where you can find the sources so you can double check my work. I'll talk more about the website and ways you can support the work that we're doing here at the end of the episode. But for now, let's get into the oral arguments for this case, Wolford v. Lopez. Lord Acton once said, "Power tends to corrupt, and absolute power corrupts absolutely." So when I see a state presumptuously use its power to corrupt people's property rights, it gets my attention. The question of property rights is the first of the two questions presented in this case, and that will be the focus of this episode. The question presented are whether the Ninth Circuit erred in holding, in direct conflict with the Second Circuit, that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public unless the property owner affirmatively gives express permission to the handgun carrier. Whether the Ninth Circuit erred in solely relying on post-Reconstruction era and later laws and applying Bruin's text, history, and tradition test in direct conflict with the holdings of the Third, Fifth, Eighth, and 11th Circuits. Can a state tell private property owners that carrying a firearm on their property is presumed to be prohibited? Or does the right to bear arms mean a presumption of permission unless the property owner says otherwise? Let's go to the oral arguments. As always, arguments begin with the attorney for the petitioner, Alan Beck.
Mr. Chief Justice, may it please the court. Bruin holds the Second Amendment protects the right to publicly carry firearms. By banning people from carrying firearms on private property that is open to the public, unless they first obtain affirmative permission, Hawaii has run roughshod over that constitutional right. The presumptive ban clearly implicates the Second Amendment. It's plain text because it regulates arms-bearing conduct. As such, the burden is on Hawaii to justify the presumptive ban with relevantly similar historical analogs, reflecting a national historical tradition of firearms regulation. Hawaii comes nowhere close to carrying the burden. Its presumptive ban defies a national tradition of allowing people to carry onto private property open to the public unless the owner objects. Hawaii's threshold position that this court should adopt a state-by-state community standard lacks support in this court's precedent, and Hawaii's argument the laws of the Kingdom of Hawaii to determine petitioner's Second Amendment rights is completely without merit.
Mr. Beck's argument focuses on the Bruin decision and the presumption of the constitutionality included in that decision. Well, that is important information. It's not the focus of this episode. Now, we go on to the arguments for the respondent, Mr. Lopez, the Attorney General for Hawaii. The arguments are presented by Mr. KATYAL.
Thank you, Mr. Chief Justice, and may it please the court. This case is about two fundamental rights, the right to bear arms and the property right to exclude. And there's lots of agreement among the parties about how those rights interact. Everyone agrees there's the right to carry on private property if the owner wants guns on his property. That was elicited by Justice Sotomayor to my friends. And everyone also agrees there's also no such right if the owner doesn't want guns. The only question is whether there's a Second Amendment right to assume the owner wants guns on his property when he's been silent. There is not. There is no constitutional right to assume that every invitation to enter private property includes an invitation to bring a gun. The Constitution protects the right to keep and bear arms. It doesn't create implied consent to bring those arms onto another's property. At bottom, that is petitioners' theory, and yet they have zero support for this. Zero support from the founding or for the next 200 years. No treatise, no commentator, no court.
Sounds like a solid argument. However, there are plenty of holes in it when you start digging into the details. This case clearly revolves around two rights in conflict: the right to bear arms and private property rights. What happens when these two rights are in conflict?
You say that there is a constitutional right to carry a gun on private property?
Yes, Justice.
I've never seen that right. I mean, I understand that there is a right to carry a gun on private property with an owner's consent, express or implicit, correct?
The Second
My
Amendment.
question is very simple. Is there a constitutional right to enter private property with a gun without an owner's express or implicit consent? The answer has to be simply no. You can't enter an owner's property without their consent, correct? Express or implicit?
Correct, because that would be a trespass.
I don't know if she realized it, but Justice Sotomayor just opened a crack in Hawaii's case. You cannot enter private property without the owner's consent. The real question of this case is, can Hawaii determine implied consent? There's an implied consent that people can enter private property for legitimate purposes. Without that implied consent, you could not receive deliveries at your door. Girl Scouts cannot sell you cookies, and your neighbor cannot come to ask to borrow a cup of sugar. This implied consent is expanded when someone opens their private property for public access. Think of a retail store, a museum, or a church. Of course, this implied consent can be terminated by the property owner.
But do you agree that all of the business owners and maybe also private property owners in Hawaii could get together and say, we don't want this, and they could not give consent? Let's say the law is flipped. It says it's illegal to enter if you have been denied permission to carry a gun on the property. You agree that all property owners could get together and say, we're denying permission, and they could put such placards up in their window, and then you would still not be able to carry a gun on 97% of the property in Hawaii?
Yes, Justice. Every private property owner has the right to affirmatively put up a sign or otherwise not give permission for people to enter a property with a firearm. The crux of our argument is that Hawaii has flipped that historical default from them having to affirmatively say guns are not allowed here to the current law.
It seems to me the issue isn't the historical default, but the question of implied consent. I'll talk more about this in the section's second-class right. Justice Jackson asked Sarah Harris, Principal Deputy Solicitor General of the Department of Justice, about the Second Amendment issue.
Ms. Harris, can we just be a little bit more specific about the Second Amendment right that you say is being infringed here? This is the point that I guess I'm still stuck on, is whether or not in a world in which we all concede, and I think the United States is on board with this, that the Second Amendment yields to the property interests of a private property owner, such that the private property owner gets to consent as to whether or not you can carry a gun on his property. When we're in that world, what Second Amendment right is being infringed when the property owner says no, or when the state says the property owner's consent has to be expressed?
There is a world of difference between the two scenarios Justice Jackson put forth. When a property owner says no, they are exercising their property rights. When the state says your implied consent does not extend to the right to bear arms, they are infringing on the right by treating it as a second-class right. During questioning, Justice Barras brought up the question of public versus private property.
Counsel, do you agree that the state as property owner could exclude someone, not this implied consent law, but let's say that the state as property owner, put aside the fact that the sensitive places here include state-owned property, assume that that's not so. Could the state, as a property owner, say that you can't carry a gun onto state-owned property as a matter of consent under property law?
No, Your Honor. I think that's a different analysis because
Okay, why?
now we're dealing with direct state action.
This question is more important than it may seem at first because it gets to the question of public ownership. Governments, as in state, local, and federal, own property, and like any other man-made entity or artificial person, as used in the law, they hold that property in trust for the people they represent. The state may own the property, but it was paid for by the people of the state, making them the ultimate owners. As such, they do not have the private property right to determine usage, since the people who are in government are representatives of the people themselves. This means that states are bound by the Constitution of both their state and the United States, which says the right of the people to keep and bear arms shall not be infringed. What about private property that is open to the public? This is commonly referred to as a place of public accommodation.
We've been talking about private property and public property. A gas station on the side of the highway is private property. It's owned by the gas company or whatever. Do you assume that you have the right to go on that private property even without any express permission?
Yes, Your Honor.
Even though it's private property?
Yes, absolutely, Your Honor.
Is there, under our law, an invitation, for example, for people soliciting, for people who want to drop off pamphlets about a particular?
Yes, Your Honor. Up to the doorknob or the car, there is.
Even though it's private property?
Yes, Your Honor.
As I've already stated, when you open a place to the public, you extend an implied right to enter the property. Be it a gas station or a Walmart, it is implied that you have permission to enter, but does that permission include carrying a firearm? This is where we see the Second Amendment treated as a second-class right.
So suppose there were a state that said, we're going to flip the default rules so that you cannot leaflet in shopping centers unless you secure permission first. No. Would that be constitutionally problematic or not?
The problem there is that oftentimes in the First Amendment context, the First Amendment rules are different than the Second Amendment because they forbid content discrimination and viewpoint discrimination. And a leafleting law often will have some sort of illicit thumb on the scale for a certain set of viewpoints.
I wish to remind Mr. KATYAL that the first 5 words of the First Amendment are Congress shall make no law. So a law that Justice Kagan describes, where the state restricts the distribution of leaflets, cannot violate the First Amendment because Congress did not make the law. But notice the underlying premise. Your implied consent to enter private property includes First Amendment protections, but not Second Amendment ones.
And it strikes me that one of the things that your side of the case has to come to grips with is that it is a very clear constitutional right under the First Amendment. If I, for example, as a candidate for office, want to walk up to your door on private property and knock on the door and say, here, give me your vote, that's exercising the First Amendment right. But you say that it's different when it comes to the Second Amendment, that you can walk up. So when the candidate wants to walk up and he's carrying a gun, what exactly is the basis for the distinction? Because part of, again, what our precedents talk about in this area is that the Second Amendment has been treated as a sort of, a second-level right. And that's one area where given this law, I don't really see the basis for the distinction.
So we totally agree the Second Amendment is no disfavored right. At the same time, there are rules about the Second Amendment, I think rules that this Court laid down in Bruin, in which you've said the relevant question is whether or not the scope of the Second Amendment's text as informed by history would say that there is a violation of the right.
We totally agree. The Second Amendment has no disfavored right, but here are the rules that disfavor it. This argument would be laughable if it wasn't so serious. Justice Barrett took the arguments even farther.
Let me one more question. So let me take it out of the First Amendment for you. I mean, let's pretend that public accommodation laws don't exist, because the 14th Amendment doesn't apply to private action, only state action. Let's say that a state, in the absence of public accommodation laws, decides to flip the default and say, unless the owner affirmatively consents, black people cannot enter your home.
Yeah, so I think that's one which would be unconstitutional
Why?
every day of the week because it would violate the Equal Protection Clause, because the government on its face is making a racial classification. So
Because there's state action in the way the government is adjusting its property defaults.
Absolutely.
Even if there's a long history and tradition, say, in Louisiana,
Yeah.
of this kind of discrimination at the doorstep.
right, it would still violate the Equal Protection.
Why isn't there state action here when the state is flipping the default? It's not just a matter of property law.
Why is a state action a violation of equal protection of race, but not firearms? After all, if the Constitution is the supreme law of the land, as Article 6, Clause 2 states, shouldn't it apply equally in such cases? Mr. KATYAL's response to this line of questioning truly shows the arrogance and overreach of the state of Hawaii.
Our point is not that whether there's state action or not, it's that there's no underlying right. It's that my friend assumes, is conceded this. He said there is no right to come onto private property absent consent. And so the only question is whether the state can fill in the conditions.
Yeah, there's
of
no
that
right to
consent.
come onto private property without consent.
Notice the language switch. No one argues that you have no right to enter private property without consent. That is not the question here. The question here is, does Hawaii have the power to determine the level of consent necessary to enter private property they do not own? Put another way, does the state have the legal power to control access to your property for you? Justice Alito helped Mr. KATYAL bury this Second Amendment right even deeper.
You're just relegating the Second Amendment to second-class status. I don't see how you can get away from that. If someone owns a store, or let's say it's a little restaurant, and this person has very strong political opinions and does not want anybody in that restaurant who is wearing attire that is expressing approval of a particular political candidate, that person, the owner of that restaurant, has the right to say, you can't come in, right?
Yes.
All right. Now, could Hawaii enact a statute that says that if you are wearing the attire expressing approval of a particular political candidate, you can't come in unless you get express consent from the owner of the restaurant?
Again, that's a viewpoint discrimination and prohibited.
It's a
by the
violation of the First Amendment. We have a violation of the First Amendment and a violation of the right that the court held is protected by the Second Amendment in Bruin, which is the right of law-abiding citizens to carry a firearm for purposes outside of the home for purposes of self-defense.
I quite agree with much of what you're saying. I think what's the difference is that the Second Amendment, it's not a second-class right. It just doesn't have the same components of viewpoint discrimination or anti-discrimination for the 14th Amendment. That's just not in the Second Amendment.
The Second Amendment is not a second-class right. It just doesn't have the same components of viewpoint discrimination or anti-discrimination for the 14th Amendment. Why not just claim separate but equal when it comes to these rights? I guess the viewpoint of the right to carry firearm doesn't count for Mr. KATYAL. Justice Jackson seemed to throw Mr. KATYAL a lifeline.
And what you're saying, I think, is that there is no Second Amendment right to assume implicit consent.
There's not a Second Amendment right to implicit consent, but it does require that it not be infringed. Besides, there's a Fifth and 14th Amendment right for the property owner not to have the state decide for him who shall and shall not be allowed onto his property. It seems rather obvious, based on this and other laws, that the lawmakers in Hawaii really do not like the Second Amendment. Since those lawmakers were elected by the people of Hawaii, I can only surmise that they don't like the Second Amendment much either. Justice Thomas and Alito made this point during their questioning of Mr. Beck.
You argue that this law prevents access to about 97% of public areas. How do you arrive at that?
We are not arguing this specific law is banning 97%, Your Honor. The overall package of laws passed by Act 52 presumptively bans carry on 96.4%. And we arrived at that figure by having an architecture firm go through the public records of the County of Maui to determine which areas were regulated by this package of laws, Your Honor.
96.4% of the public areas of the state of Hawaii prevent access to anyone, any civilian who carries a firearm. Remember, law enforcement is not prohibited from carrying firearms in these locations, only civilians, the citizens. So it appears that Hawaii just has it out for the Second Amendment, and Justice Alito nailed that point.
Under Hawaii law, are there any other objects besides guns that a person may not possess when that person enters private property that is open to the public?
Not to my knowledge, Your Honor.
This seems to be a clear case of attempting to demote the Second Amendment from its rightful place as the supreme law of the land. It also seems to be an example of Hawaii trampling property rights. If someone doesn't want hunters, solicitors, or trespassers of any kind on their property, all they have to do is post a sign. Why should the right to keep and bear arms be any different? I know there was a lot of discussion about the Second Amendment, the right to keep and bear arms, but really I see this as a property rights issue. Hawaii is telling private property owners the rules for people to enter their property. That is a violation of the 14th Amendment. It deprives them of control of their property and deprives them of their liberty without due process of law. If I have an inherent right to enter someone's property for legitimate reasons, then why should it be different if I'm carrying a firearm? If they don't want it, put up a sign. Of course, I suppose the argument could be, well, if they want people on their property to carry guns, they could put up a sign for that too. But the question is, who gets to decide? Why is the Second Amendment treated as a second-class right? Because people don't like guns. They're hoplophobic. They have an irrational fear of firearms. But it's interesting, they only fear those firearms in the hands of civilians, which pretty much defeats the purpose of the Second Amendment to begin with. Now, I'm curious what you think about this. There's a lot we can go into, and we'll wait to see what the court comes to a decision in this specific case. Now, you can find out more by following this and other cases by going to the website constitutionstudy.com. Sign up for a mailing list. There's one for all my articles, and you can be notified every time I publish new content. There's one for news events, and also you can also head to the store, maybe pick up a book or a T-shirt or a mug, or just donate to the cause. All of that helps. Spreading the word, buying product, helps support the work that we're doing here at the Constitution Study. Of course, you can also help with your cell phone. Yes, your cell phone. Patriot Mobile is America's only Christian conservative wireless provider. They share our viewpoints. They share our desires. They take a portion of every dollar they make to support organizations like the Constitution Study that are trying to help you defend your rights. Find out more by going to patriotmobile.com/constitution. Find a plan that works for you. You may be eligible for a discount as well. And then when you check out, use the code Constitution to get your new line activated absolutely free. That's right. You can defend your rights with your cell phone by going to patriotmobile.com/constitution, finding a plan that works for you. Hey, again, check for discounts. Everyone from first responders to families with multiple lines are eligible for discounts. Then don't forget to use that code Constitution at checkout to get your new line activated absolutely free. Mostly, I hope you'll come back and share this content, but come back maybe with a friend or two the next time we meet here for the Constitution Study.